Hi, I'm Jonathan Cohen from Nextlaw. One of the most common things I hear is, "Let me explain what really happened," or "I have a good reason for driving that way." Here's the truth. In stunt driving cases, your story about why you were driving that way almost never matters in court. What is strict liability? Stunt driving under Section 172 of the Highway Traffic Act is a strict liability offense. This means the court doesn't care about your intentions or reasons. If the officer's evidence shows you committed the act, you're guilty. It doesn't matter if you were rushing to the hospital, didn't realize your speed, or thought the road was safe. The law focuses on what you did, not why you did it. Why your viewpoint isn't evidence. Your version of events isn't considered evidence in court. The case is built entirely on the officer's observations, their radar or LiDAR readings, their notes, and their testimony under oath. What you believe happened is just your perspective. Without corroborating evidence like dashcam footage or independent witnesses, it holds absolutely no weight in the legal process. How excuses damage your case. When you try to justify your driving to prosecutors, you're actually hurting your position. Prosecutors hear excuses every single day. When you say, "I was only trying to pass quickly," or "I didn't think I was going that fast," they see you as someone making excuses rather than taking responsibility. This makes them less willing to negotiate and more likely to push for maximum penalties. Your explanations convince them you're a risk to other drivers. What the court actually examines. The court examines technical elements. Was the speed measurement device properly calibrated? Did the officer follow correct testing procedures? Were calibration records properly maintained? Was the radar or LiDAR used correctly? Did the officer have proper certification? These are the questions that determine your case outcome, not your explanation of why you were speeding. Real example of why stories fail. I've seen clients tell prosecutors they were speeding because they were late for work. The prosecutor's response? That makes you more dangerous because you prioritize convenience over safety. Another client explained they didn't see the speed limit sign. The prosecutor argued that proves you're an inattentive driver. Every excuse you offer generally ends up having the opposite effect that was intended. This can jeopardize your case. What you should do. Get proper legal advice. This isn't a regular speeding ticket. You risk losing your license for a 1-year minimum or worse. At Nextlaw, we focus exclusively on stunt driving defense. We utilize the law and our relationships in Ontario courts to minimize your charges and keep you driving.